John, let me know when you're filming, John. Now.
All rise.
Yes, good morning, Court. My name is Lady Kate Whiting. The Court sits today to hear the case of A, D and G versus F. Counsel, will you please proceed to make your submissions regarding the charge today that one claimant, Mr. F, is liable for negligence? Thank you.
Lady, my name is Peter, and I'll be arguing for the claimants this morning. Co-counsel includes Shelby and Alex. First, I'd like to introduce you to the facts of this case. Adam is a soccer coach for a team based in Oxford and scheduled a tournament in London. He drove two of the team members, Toby with the twins, Clive and Darren. The twins sat in the rear seats. Darren without a working seatbelt, and Adam's own son, Evan, sat in front. A celebrity soccer player overtakes Adam's vehicle and moves by a shout, momentarily distracting Adam. Another motorist, the respondent, Fergus, maneuvers his car into Adam's lane without looking. When Adam sees the car, he is so close that he has to brake very hard. Darren, due to his lack of a seatbelt, hits the back of Adam's head, breaking his nose and causing Adam to momentarily lose consciousness. Adam's car swerves off the road, hits a road sign, and damages the car. Darren has a rare medical disorder that causes him to bleed severely from his broken nose. Graham, another road user, and brother of Adam, sees the accident and suffers psychiatric injury due to trauma and disease. So the first issue I want to address is the duty of care. In order to further exemplify what the duty of care is in this situation, being that it is perhaps the most debated area of negligence law and also most misunderstood, we'd like to refer to the case of Donahue versus Stevenson, the case in which this area of tort law was originated. Lily, I'm sure you're aware of the facts of this case, but I'd still like to continue with the reference so the court may better understand.
Indeed, thank you.
Mrs. Donahue went to a cafe with a friend. The friend brought her a bottle of ginger beer and ice cream. The ginger beer came in an opaque bottle so that the contents could not be seen. Mrs. Donahue poured half the contents of the bottle over the ice cream and also drank some from the bottle. After eating part of the ice cream, she then poured the remaining contents of the bottle over the ice cream and decomposed snail emerged from the bottle.
Mr. Sample, sorry to interrupt you. Could you just raise your voice slightly, please?
Sure.
Thank you.
Mrs. Donahue suffered personal injury in her stomach for reasons I'm sure you can well imagine as a result. She commenced a claim against the manufacturer of the ginger beer. What is the duty of care in this situation? How does it apply to the case that we are dealing with? The duty of care in the Donahue versus Stevenson case, as stated by Lord Acton, the judge of this case. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. The neighbor is anybody so closely and directly affected by your act of use, ought to reasonably being the key word, have them in contemplation as being so affected when directing your mind to the acts or omissions in question. In other words, a manufacturer is guilty of contributory negligence under the rule of duty of care, and a claimant was successful. Now, how can the judge's statement regarding this case apply to this case? Well, we can easily see that Fergus is blatantly guilty of negligence on account of the duty of care because of the fact that Fergus maneuvered his car without looking into the lane that Adam's car is driving in, causing him to apply his brakes and swerve into a road sign, damaging his car. If I may, lady, I'd like to refer to the Anne B. Merton case. I want to assist in addressing this three-stage test care for duty of care. Are you familiar with the case?
I am, thank you.
Alright, so as a result of this case, a three-stage test for duty of care was created. This three-stage test is as follows. Number 1, is it reasonably foreseeable that another person will be injured by your actions? Number 2, is that a person sufficient proximity to you in both time and place? And number 3, is it fair and just and reasonable to impose a duty in the case? Now applying this to our case. It is reasonably foreseeable to Fergus that another person could possibly be injured by switching lanes without looking. And this would also be undoubtedly This would undoubtedly be yes. If Fergus had looked before he switched his lanes, the situation could have been well avoided. He was also in sufficient proximity in both time and space. We find that it is also fair and just and reasonable to impose a duty in this case, since Fergus failed to take reasonable action by looking before he switched lanes.
Mr. Sample, can I interrupt you there?
Yes.
You've referred to the case of Donahue and Stevenson and said that the injury must be reasonably foreseeable.
Yes.
Can I just ask you, given the chain of events that occurred, do you actually think that the respondent foresaw this at the time?
Yes, because as an adult driver, he has a responsibility to know that there is reasonable there is reasonable cause for danger by switching lanes without warning. Does that make sense?
Okay, yes, thank you.
Now the next issue I want to address is the breach of duty. A breach of duty is when the respondent fails to exercise a level of care that a reasonable person would in that situation. As we mentioned earlier, the respondent failed to exercise reasonable care by not looking before he switched lanes. Now I'd like to refer to the Wilshire versus Essex case. Are you familiar with the facts?
I'm not, can you please repeat them to the court? Thank you.
A premature baby was given too much oxygen by a junior doctor. The baby suffered from a condition affecting his retina, which left him totally blind in one eye and partially sighted in the other. The condition could have been caused by the cases by the excess oxygen he had been exposed to, or it could be caused by 4 other factors unrelated to the oxygen, related to the premature birth. The trial judge found the health authority liable. The defendant was in breach of duty. A junior doctor was the same standard of care as a qualified doctor. This can be applied to our case by relating the fact that although Fergus wouldn't be considered technically a professional driver, he's still considered an adult driver, and therefore has responsibilities no driver to change the lanes without looking. The last thing I wanted to bring up is the doctrine of causation. The doctrine of contributory negligence states that when Clive and Edmund were shouting in the car, causing him to be distracted, the claimant failed to take reasonable care for his own safety by not paying proper care and attention. While it is in fact true that Adam was not paying attention for a short split second, he's still not liable for the accident, because it wasn't the shouting, was not a proximate cause. If Fergus cutting them off, the accident wouldn't have happened. Also, I think it should be noted that distraction was not caused by direct action from the claimant, but for an external distraction that was out of his control. Therefore, the doctrine of contributory negligence does not apply. Lady, if you have no further questions, those are my submissions.
So your argument is that the doctrine of contributory negligence does not apply?
Yes.
Okay.
Simply because he wasn't paying attention, but he was not responsible for not paying attention. It was, shall we say, external distraction that couldn't have been helped.
From the children in the car who were shouting? Okay, thank you.
My lady, my name is Shelby Rooney and I am representing the claimant, specifically Dick. Darren is suing Fergus for negligence for his broken nose and bleed. It has already been established that the respondent owes my client a duty of care, as well as the fact that the duty of care was breached. It shall also be established that the breach, in fact, caused the harm, fulfilling the third element required for negligence. I'd like to look at Fergus's causation that can be broken down to 2 parts, the factual and the legal. The standard for factual causation was set in the case of Barnett versus Chelsea Hospital. Are you familiar with the case, Melody?
I am indeed, thank you.
It was held that the hospital was not liable because the doctor failing to examine the claimant did not cause his death, and this established the but-for test. This test is, but for the respondent's breach of duty, would the claimant have suffered the harm? And the answer to this test is no. Darren did not have a seatbelt on, but the ride up until the accident was uneventful. Darren only flew out of his seat because Fergus cut in front of the vehicle, directly causing Adam to have to slam on his brakes. The legal causation against Fergus can be established by referring to the case of the wagon mound. Are you familiar with this case?
I am not, could you please repeat for the court? Thank you.
The respondent's vessel, called the wagon mound, leaked furnace oil at a wharf in Sydney Harbour. Cotton debris became stuck in the oil and sparks from nearby welders ignited it. The fire spread rapidly and over a large area, causing the destruction of several boats at the wharf. This established the test was the harm of a kind that is reasonably foreseeable. Hence, Fergus too will only be liable if the kind of harm that occurred was reasonably foreseeable. And in this case, it was. The harm caused to Darren, a broken nose and extensive bleeding, was reasonably foreseeable, because naturally, if a car is cut off, they will have to slam on their brakes. And slamming on the brakes would naturally lead the occupants of the vehicle to be bumped around and injured, hence experiencing physical harm. Darren's harm was of a physical nature as well, and can therefore be considered reasonably foreseeable. My learned friend for the respondent may present that the manner in which the harm occurred, because Darren didn't have his seatbelt on, was not reasonably foreseeable. However, an important precedent was set in the case of Hughes versus Lord Advocate. Are you familiar with the case, my lady?
I am, thank you.
It was held that as long as the kind of harm sustained was reasonably foreseeable, The exact manner in which it occurred does not have to be reasonably foreseeable. A reasonable man would have foreseen that completing a lane change without looking and subsequently cutting another motorist off would lead to physical injuries for the occupants of the vehicle. Hence, the fact that Darren wasn't wearing a seatbelt does not have to be reasonably foreseeable because the possibility of physical injury was reasonably foreseeable. Hence, the factual and legal causation are established, completing the third necessary aspect for negligence for the claim of Darren.
Yes, if I can just interrupt you there. I agree that physical injury was reasonably foreseeable. However, could Fergus have foreseen that Darren would not be wearing a seatbelt? And do you not think the other side may argue that if he was wearing a seatbelt, that physical injury would have been avoided? I'd just be interested to know what you think about that point.
I believe that the doctrine of contributory negligence would not apply in this case because even though he did not have a seatbelt on, there was still a chance that he would have been physically injured had he had it on.
Okay. Thank you.
My learned friend, the respondent, may also argue that severe bleeding was not reasonably foreseeable. However, the thin skull rule applies in this case. Are you familiar with the case of Smith versus Leach Brain, my lady?
Could you repeat it for the court, please? Thank you.
A widow brought a claim against the defendant under the Fatal Accidents Act for the death of her husband. The defendant employed the husband and the husband received a burn to a lip as a result of the defendant's negligence. The lip contained precancerous cells which were triggered by the injury, and the man died 3 years later as a result. It was held that the employer was liable because the burn was a foreseeable consequence of the defendant's negligence and directly resulted in death. It is not necessary to show that death by cancer was foreseeable or that an ordinary person would have died from this injury. The thin skull rule applies, and the defendant must take the victim as he finds him, even though the victim was extremely vulnerable in the situation. The type of harm, physical injury and bleeding, was reasonably foreseeable, so it is irrelevant that the extent of bleeding was not reasonably foreseeable. Darren suffers from a rare disorder that caused him to bleed severely, and he must be protected by the court, even though, or rather especially, because he had a medical weakness. The doctrine of contributory negligence is another point of law that may be raised by my learned friend for the respondents. It may be argued that Darren is partially to blame for the harm he has suffered because he did not take reasonable care for his safety by failing to use a working seatbelt. However, Darren is only 12 years old. The standard for reasonable care for a child under the law has been established in precedent to be less than that of an adult. Take the case of Latchik versus the Oliver Blars Company. The defendant supplied a young boy with a pint of petrol because he had falsely stated that it was for his mother's car. He then used the fuel to make a burning torch for a game and suffered severe injury as a result. The defendants were held liable in negligence in this case. The boy was not guilty of contributory negligence because he did not know and shouldn't be expected to know of the danger that might occur. There is a very similar case in Gow versus Thorne. The claimant, a 13-year-old girl, was waiting to cross the road and was beckoned to proceed by a driver. She began to cross the road and was struck by contributory negligence for relying only on the driver's signal to cross the street because, quote, a very young child cannot be guilty of contributory negligence. And this was stated by Lord Denning. Similarly, Darren, who is only 12 years old, should not be held to the adult standard of reasonable care because he did not foresee the possible consequences of failing to use the seatbelt, and, as established in past precedents, should not be expected to at his age. Hence, the doctrine of contributory negligence is irrelevant in terms of Darren. Alternatively, my learned friend may establish that Adam is liable under contributory negligence for failing to ensure that Darren was wearing a seatbelt. We do concede on this point because in all regards, Darren should have been wearing a seatbelt. However, because of the diminished standard of care and the lack of contributory negligence for Darren, as well as the fact that it was Fergus who caused the accident and the harm, we feel that the doctrine should not apply and no reduction in damages should occur.
Could I just ask you one question here? You're right to refer to those cases, but what I want to ask you is, surely a 12-year-old child would realise that they have to take precautions for their own safety, and if he hasn't worn a seatbelt, it does seem unfair that the respondent will be held fully liable in damages for that. Even at the age of 12 years old, you should be able to foresee that this could lead to injury being caused if an accident occurred.
We do concede on the point that he may have foreseen that some kind of injury was would occur. However, he would not be able to foresee the extent of the injury that would occur.
So it's your argument that contributory negligence just doesn't apply at all here?
Yes, due to his age
Okay,
and
thank
past
you.
precedents. So ultimately, Fergus is liable for negligence, leading not only to the damage on Adam's car, but Darren's broken nose and severe bleeding as well. The respondent had a duty of care, breached it, and the breach directly caused the harm, as seen through the establishment of Fergus's factual and legal causation, and the application of the thin skull rule, the lack of application of the doctrine of contributory negligence. As my learned friend for the claimants will now present, Fergus was also negligent to Graham in causing him psychiatric harm.
Sorry, could you just try and finish within the next 30 seconds?
Subject to further questions, my lady, those are my submissions.
Thank you very much.
My lady, I am representing the claimants and in particular arguing that Fergus is liable in negligence to Graham. Fergus is mainly liable for causing Graham psychiatric injury as a result of the accident. To show that Fergus is responsible, I would like to go through the fact that he owed her a duty of care and that he breached the duty. The duty of care that Fergus owed Graham was to be a responsible driver, and as he breached that duty, causing the accident between the claimants and himself, he caused a traumatic scene which influenced Graham. He had a duty of care because it was reasonably foreseeable that by causing that accident, someone could be injured by his actions. And as Graham was in sufficient proximity to Fergus during the accident, this is also a point that shows he is responsible. He also breached that duty by causing the accident, and breached the
Counsel, may I ask if you're familiar with the case of McLugan versus O'Brien? I believe this is a very important case here for establishing a test to be applied.
Yes, in the case of McLugan versus O'Brien, a lady, her husband and two of her children were involved in a serious accident.
Yeah.
And as she went to the hospital, and my lady may I know who this for?
Pardon? Yeah, of course.
In the case of McLugan and O'Brien, a lady's husband was involved in an accident, as well as two of her children. As she visited them in the hospital, she witnessed one of them was dead and they were seriously injured, and their bodies were still covered in oil and mud. This contributes to the fact that the trauma did not result at the scene of the accident, but later on. But nonetheless, she sued the respondent for psychiatric injury because of the grievousness of the accident.
And how would that apply to our scenario now?
Graham, who is a close relative of the claimant, would argue that because they were so closely related and he witnessed the accident and its immediate aftermath, was put into shock. Graham was also in proximate time and space, meaning he was near the accident as it occurred. And due to the result of the accident, as he swerved off the road and Fergus cut him off, it is reasonably foreseeable that Graham would suffer psychiatric trauma.
Could you just explain for the court why you think psychiatric injury was reasonably foreseeable here?
Being a close relative of the claimant, Graham would obviously have close connections, and witnessing an accident or an immediate aftermath that the claimant was involved in would naturally cause psychiatric trauma.
Thank you. you have any other submissions to make?
Those were submissions, of course.
Okay, thank you.
My lady, I am Dorian, and I appeal for the respondent, Fergus. First, I would say that Fergus cannot be completely liable for Darren's injury. As in the case study, it is said that Darren is not wearing a seatbelt. According to the law, it is highly illegal not wearing a seatbelt while the car is moving. Darren is the only person who was injured during the accident, and the only person who was not wearing a seatbelt. As a conclusion, I would say that because Darren was not wearing a seatbelt, then he was injured. Although Darren is a minor and he's only 12 years old, Adam owns a duty of care to Darren. He's supposed to make sure that every person in the car is wearing a seatbelt for two reasons. One, he's the driver. And according to the law, the driver must check that any person in the car is wearing a seatbelt. And for the second reason, because he's protecting the child in the car because Brian, his friend, asked him to. My lady, are you aware of the case of Galaska versus O'Donnell?
Could you repeat this to the court, please? Thank you.
My lady, are you aware of the case of Galaska versus O'Donnell, 1994?
If you could just explain to the
Okay.
court. Thank you.
On appeal from British Columbia. In this case, people were the driver was driving, without making sure that the people in the car were wearing a seatbelt. And after an accident, one people was injured. He was a minor, and the adult was killed. Both weren't wearing a seatbelt. He wasn't responsible for the child because he thought the father would make sure the child was wearing a seatbelt. As a result, the judge said that he wasn't responsible for what happened to the child because it was not his duty to make sure the child was wearing a seatbelt, but the duty of the father.
So in that case, there was no contributory negligence, is that correct?
Yeah.
Thank you.
So what I want to say that Darren is a minor. He's under Adam's authority, as he was taking the responsibility of Adam Brian when he affected to drive both Darren and Cliff. Furthermore, Adam is responsible for Cliff and Cliff. Although Cliff is a minor, he was shouting in the car and it distracted Adam. As a result, Adam wasn't able to check what was happening on the road. Adam is responsible for what the people in the car are doing because he's the only adult in the car and all the people in it are children. So he should make sure that the people in the car are not distracting him and are respecting the law, so that not harming the driver or not or wearing seatbelts. Although we cannot charge Darren with any responsibility in it because he's a child, we can charge Adam with negligence because he was not checking what was happening in the car. He owns a duty of care for all the passengers in his car and a duty of care for all the people outside on the road as Fergus. He should make sure that the people in the car wearing seatbelts because if people in the car get injured, then he could not be able to charge anyone outside of the car for harming people inside the car because those people in the car were not following the law.
Counsel, could I interrupt you there? You're correct that the car driver owes a duty of care to the passengers in his car. Clearly that has been breached in this case because Adam didn't ensure that Darren was wearing a seatbelt. But regardless of this, could it not be argued that when Fergus pulled into the lane without looking, Adam had no option but to slam on the brakes? He wasn't at fault there.
Yes, but if Adam was not able to brake on time, it might be for three reasons. One, he was not looking. So the second one, he was maybe driving too fast. And the third one, he was maybe driving too close to Fergus. he's coming from behind and Fergus is in front. According to the law, the person behind is supposed to check and make sure the person in front is not a potential danger for him.
That is correct, but when he pulled over into the lane, surely Adam had no option there but to put the brakes on. He couldn't have foreseen that Fergus was going to pull into the lane.
It is said that Adam was not able to see Fergus on time because he was distracted by the people in the car. If he was driving at normal speed and if he was looking what was happening on the road, maybe he could have seen Fergus moving on another lane. May I say also that Fergus never touched Adam's car. And it was only because Adam braked too strongly that the passengers harmed him and he lost for a moment his consciousness, and then the accident occurred. Maybe we could say that if Darren was wearing a seatbelt, then he would not have been able to injure Adam, and Adam would not have lost his consciousness. We can say that the other person that was not wearing a seatbelt is in fact responsible for what happened to Adam, because he was the only person to be harmed and to harm someone. Yeah, he was the only person to have a broken nose, and he was responsible for Adam losing his consciousness. Fergus may be, in fact, responsible for not looking what was happening on the lane, but as I said before, he's in front of Adam, and therefore he should pay less attention to Adam than Adam to him, because he's riding in front. Although Fergus may have forced Adam to brake too strongly, he didn't touch, in any cases, Adam's car, and therefore we could say that why Adam left the road is because he was braking too strongly, and probably because he was driving too fast. Unless you're not driving
I'm
too
sorry to interrupt. We have had no evidence today that Adam was driving too fast. This isn't something that the claimants have submitted here.
Of course.
So I'd just like your thought here. Could it not be said any reasonable person in Fergus's position would have foreseen that if they pulled into a lane on a motorway where people are driving at high speeds, an accident could have been caused?
I think whatever happened, if it was, for example, an animal crossing the road, an accident would have occurred because Adam would have tried to brake the car very strongly.
As any reasonable man would.
Yeah.
Indeed.
To prevent the death of the animal, and therefore, or maybe if it's a big animal, it's a good idea also to brake the car. And if it was not able to brake the car to prevent Darren from harming his head, it is because probably he was driving too fast, unless, because if he was driving at a normal speed, he should be able to brake the car on time, or because he was too close to Fergus, and he's not supposed to drive too close to Fergus. He should have normal space between the two cars.
Yes, I can see the argument that you're trying to make there, but for the purposes of moving on here, if it is accepted that Fergus indeed caused the accident and is therefore liable, I would like to know what your submissions are that the claimant's damages should be reduced for contributory negligence.
I think Fergus is contributed to the negligence, and Adam also, because they're sharing the responsibility. Because Adam is responsible for their inaction, then he should share the responsibility. Because I feel it's unfair to charge someone with all the responsibility, because Fergus is not responsible for Darren's action, and Darren is responsible for what happened in the car. So because Darren is a minor, he has no responsibility. His responsibility should be transferred to Adam, because Adam is the driver and responsible for everything in the car. This, I will give the floor to my learned friend, Elizabeth.
Thank you very much.
My name is Elizabeth. I am representing the respondent, Fergus. So for my case, Fergus could not be liable for Graham's psychiatric illness because, for one, Graham falls under the category of a secondary victim. This means that he was not held under any physical harm, any threat of any physical harm directly caused by the accident. And he would need to have strong relations to the victim. This is one of the 4 requirements needed to establish a claim for psychiatric injury that was established in McLovin versus O'Brien. So the 4 requirements would be to be a close relative to the primary victim, witness the accident or immediate aftermath, proximate in time and space to the accident, as well as having the foreseeable psychiatric harm. With these requirements, in our case, only Darren suffers any real physical injury because of the accident. That means like after the accident has occurred and he would have seen that his brother was perfectly fine, there could be no psychiatric illness for the shock because Graham has no personal relations to Darren because they are not at all related, so he could not have claimed for psychiatric illness. He is only linked to Adam, and Adam's main problem was his car.
So not physical damage.
There's
just
no physical
property
damage to Adam, and there's only property damage.
Okay.
So it could not be held as liable. It is also important to note that Darren's injuries are limited to only a broken nose and severe bleeding, which is not as brutal as what the other primary victims of other cases have to suffer, like the ones in Hintz versus Berry. Are you familiar with the case, my lady?
I'm not, I'm afraid.
In Hintz versus Berry, a couple, along with 4 of their own children and 4 adopted children, went to go to have a little picnic. But then when the mother went with a few other children to pick up bluebells, they saw a jaguar crashing into their car that they parked it for the picnic, killing the husband and severely injuring the rest of the children. When you could see that the brutal aftermath of the accident, it makes sense for the wife to suffer from psychiatric illness, but however, in here, the only injuries that sustained physically would be Darren and a broken nose with severe bleeding. I don't think that it is fair that you put the same injury of like a broken nose as the same as a death and severe injuries with broken bones and such. I don't think it is fair to judge it the same way.
And in any case, Darren isn't actually related
Yes,
to
and
Graham.
in any case, Darren isn't related to Graham. So the argument for Graham being liable by Fergus is also not able, like he can't ask for damages or recompensation for it. That's the main argument. So if there's no questions, my lady, that's my submission.
I wonder if I could just ask you, in any case, whether you believe that psychiatric injury was reasonably foreseeable in this case.
Psychiatric injury would not be reasonably foreseeable in this case because there is no way for Fergus to know that Graham is in the same road as he is. He could have thought that if it was a bystander, there would be bystanders. But that he would have not known that one of the bystanders who witnessed the accident could have been Fergus's brother. Graham's brother. Adam's brother, sorry.
Yes.
Yes.
Thank you very much.
Lady, I would like to start off by saying that Adam did have a duty of care to Darren to ensure that he had a seatbelt on. We can see it on this point.
Yep.
However, Adam had no option but to brake extremely fast and hard. He couldn't have foreseen that Fergus was to change lanes and cut him off without looking, and this mitigates the effects of this point. Also, Adam is unable to control the actions of the children. He could not predict that a celebrity soccer star would drive past and that the children would shout. Hence, he should not be seen as guilty for contributory negligence in this case for not controlling the children. Also, nowhere in the statement of facts does it say that Adam was speeding, and the accident is the sole responsibility of Fergus, so he should be held liable. Fergus is much more liable in this case than Adam is, as Fergus had control over his actions while Adam experienced a series of unpredictable events in which he responded in a manner that a reasonable man would. As for the psychiatric injury, it is true that Graham was a secondary victim. However, he was linked to Adam and Evan in the car, his brother and his nephew. And he could foresee by experiencing the accident that harm could occur to those that he was extremely close to, and therefore he is able to claim psychiatric injury. He passes the test established in McFarland versus O'Brien, that the nervous shock was a foreseeable result of the injuries to the claimant's family, and it was reasonably foreseeable because a person who witnesses their brother, nephew, and 2 other innocent children nearly being murdered in a huge car crash would likely experience some kind of trauma or injury due to witnessing these events.
Do you agree that he wasn't actually related to the primary victim in this case?
I do agree. However, he, by witnessing the accident, he could foresee that the people who he was related to could have experienced severe injuries as he saw the car flying off the road. Those are my submissions.
Thank you very much. Yes, I thank you, counsel, for the claimants and counsel for the respondent for presenting your arguments today. Court, we have heard this morning the case involving Fergus and these 3 claimants, Adam, Darren, and both sides have presented legitimate, and Graham, both sides have presented legitimate and indeed persuasive arguments in favour of their clients. However, there can of course be only one verdict reached in this case. To focus solely on who should win this case as a matter of law, it is my decision that the respondent Fergus should indeed be found liable in negligence to Adam and Darren, but I will add a number of caveats here. Court, it is clear, as counsel have argued, that one road user owes another road user a duty to take reasonable care, which was clearly breached by the respondent in this case when he manoeuvred his car without looking into the claimant's lane. Any reasonable man in such a situation would have foreseen that an accident could have been caused, and Adam clearly foresaw this in this case. It cannot be disputed, however, that Fergus's failure to check was wholly unreasonable, reckless and dangerous, a point that has been raised by counsel. We have heard today that a number of complex issues arise regarding the causation element in this case. Counsel for the respondent have argued that it was the claimants Adam and Darren who truly caused the accident by failing to wear a seatbelt. This is indeed a reasonable accusation to make and an argument that has been well presented, but nonetheless one I regard as insufficient to hold the respondent not liable. It is my conclusion, as counsel for the claimants have persuasively argued, that but for the respondent's clear failure to take reasonable care, the accident would not have occurred. Counsel for the claimant Darren have also correctly identified and applied the thin skull rule, in holding it is irrelevant that the injuries suffered by Darren were more extensive than Fergus may have foreseen, but in any case a person must take their victim as they find them. As a matter of law, therefore, I find that Fergus was the cause of the accident and therefore liable in negligence to Adam and Darren. Having said this, I would agree with counsel for the respondent on 2 points today. The first is that whilst I do not agree that the claimants Adam and Darren caused the accident, I do agree that they are at least guilty of contributory negligence by failing to wear a seatbelt, and in Adam's case by failing to ensure that his passenger wore a seatbelt. This failure to take reasonable care for their own safety clearly contributed to the harm that they suffered as a result of the accident, and as such I would agree with counsel for the respondent that their damages should be reduced. I also agree with counsel for the respondent on the claim brought by Graham for psychiatric injury. You have correctly identified that Graham is a secondary victim, as he himself was not involved in the accident and suffered no physical injury. They have also referred to the case of McLugan versus O'Brien, which holds that in order to bring a claim, the secondary victim must be a close victim of the primary victim, and that victim is the one that suffers physical injury. It is correct, as counsel for the claimants have argued, that Graham is a brother of Adam, but what is fundamental here is that Adam is not suing for physical injury and therefore cannot be classified as a primary victim. So therefore the test in McLugan versus Bryan is not made out. Court, I thank counsel for their submissions, and I now pass the following judgment today. That Fergus is liable in negligence to Adam for the damage to his car, that Fergus is liable to Darren for the injury to his nose, but that Adam and Darren are guilty of contributory negligence due to the failure to wear a seatbelt, and that their damages should therefore be reduced. And finally, that Fergus is not liable to Graham for psychiatric injury. That concludes my judgment. Thank you. Do you want to say a few words?
I've participated in many moots, having studied law at both Cambridge and Oxford. And first I want to give my compliments to Her Lordship, and I thought she did a brilliant job actually in judging this. It was an extremely complex case.
Even I made a mistake, as I forgot the name of one of the claimants.
This
happens
happens
to the
in
best
court,
of
my
us.
Lordship.
Yeah.
I also want to add that during breakfast, I just couldn't believe that the five of you would be nearly prepared in taking a case this complex, arguing it intelligently, and presenting your cases really as fluently as you have. I think it is absolutely remarkable. It's really quite extraordinary. And I want to really tip my hat to all five of you. You've been trained extremely well, and that's Kate, and you have performed brilliantly. And I think we owe you a real round of applause for that. Thank you very much indeed.
Especially bearing in mind that most of you had never studied law before these 2 weeks, so that was brilliant. Well done, guys. Okay. The end.